Welcome everyone to Framed, How Law Constructs and Constrains Culture. Many of you may remember Terry Gilliam's wonderful animations for Monty Python's Flying Circus, hilarious and often slightly disturbing collages of images that were inevitably squashed by a massive foot. Gilliam borrowed hundreds of images to create these animations, yet at the time, this was in the early 70s, no one protested. Fast forward 20 years to 1995, when Gilliam's making the movie 12 Monkeys, and becomes involved in at least two publicized intellectual property disputes. The first, the case of Woods versus Universal City Studios. 29 days after the film's release, a court stopped further distribution of the film because an artist claimed that a chair that appeared in less than 5 minutes of the 130-minute film infringed a graphite sketch of a chair that he had drawn some years earlier. Gilliam reportedly also had to pay $35,000 for Andy Warhol's Xerox of Da Vinci's Last Supper, which appeared in the background of the film, a work that, of course, was itself a copy of another pre-existing work. What would happen if we actually applied these rules to the world of documentary film? Documentaries are, of course, records of our culture, and our culture is full of legally protected materials, films, songs. Filmmakers must often clear the rights to all of these protected materials, whether they're the focal point of the scene or merely an incidental or fleeting detail. Interestingly, though, documentary filmmakers are not merely in the position of infringing other people's rights. They're also in the position of asserting their own rights with respect to their own works. They may want to receive payment, they may want to prevent certain uses of their footage, or they may want to honor agreements that they've made with the subjects of their films. How do we draw the lines between the need to access protected content in our documentaries and our desire to protect our own works after production? How is art framed by the way the law strikes this careful balance? That's going to be the subject of our first panel this morning, Culture on the Legal Cutting Room Floor.
I'm really, on the other side of most of the people on this panel because I'm kind of the instigator. I'm the artist, the filmmaker who has a passion about an idea and is desperate to have some kind of footage or music or something in their film that they can't let go of, and call for the help of some kind of legal aid in allowing this to be in the film. And sometimes it works out and sometimes it doesn't. And at the same time, I'm also on the other end because we do sell portions of our films to other filmmakers, and so we are also on the end of wanting to get some kind of compensation and protection for our own footage. So we live on both sides of this issue. Through the years, I think a lot of the issues have changed for us as filmmakers, and I thought I would start by showing a piece of my partner Penny Baker's film, Don't Look Back, which is a film about Bob Dylan's 1965 concert tour.
I don't think it's cool to be an anarchist. It's cool. No. Oh, sure. Remember, it's not. I don't think it's cool.
What's missing here? Filmmakers may know, which, yes, exactly. It's your 10 minutes of music credits and such, and publishers and everything that you see at the end of films nowadays. Things have changed and evolved greatly since then. I mean, within the film, there's a scene. I don't know if any of you've seen Don't Look Back, but there's a scene where there's a party and Donovan kind of comes in and joins Bob Dylan, and he's very much in awe of Bob Dylan, and he's brought his guitar, of course, and he sits there and he plays a song for Bob Dylan, and at that point, that time, we didn't even bother to clear that song because he was just playing in it, and that was seen more as part of the art of the film, and not something that you had to gain the rights to. Although the songs that Dylan sang in concert, we did get the rights to at that time, but other pieces of music that today would be, very controversial if you didn't clear them, were just kind of left as, that's just a given. I think, technology, the advent of tape, audio tape, the advent of the cable market, everything, there became more markets for things and more value for things. And, it's proceeded to today where songs that 10 years ago we might have paid $1,000 for now are, $7,000 to $10,000 for the same piece of music. So it's become very much of a business for filmmakers, and because of that, it's caused a lot of problems. The next piece is a piece from a movie called Depeche Mode 101. They had bought this music box, I think in Times Square, and it was playing Raindrops Are Falling on Your Head. And we could not get the rights to that song. We could not afford the rights to that song. And so we changed the song to London Bridges Are Falling Down. And we had to kind of edit it in the scene here, you'll see. Next are some examples of things that we just claimed fair use and used. And there's a piece from the War Room where Ross Perot's campaign, Ross is quitting, and I think he's playing a Patsy Cline song on television.
It's a campaign that cost at least $60 million.
There's a piece from Depeche Mode with the kids who we also filmed that were following their tour on a bus with a cartoon on it. We claimed fair use. We cleared that music, though. And then there's kind of and Martin playing a video game. We also claimed fair use. And then kind of a montage sequence that we used it in that's probably a bit questionable.
Route 66, all right, I'm down with that. Well, if you plan to motor west.
They're posing as the band. I put this in really as a piece of Monterey Pop because we sell footage of Janis and Jimi Hendrix quite often from this film, but quite often people just use it. And I'm putting it as an example of what often happens for news stations or commercial television like NBC will use this footage for some piece that they're doing, and their lawyers have said that basically they don't even bother to clear the rights for it. They just wait and see if the filmmaker finds out and comes after them, and then they'll just negotiate it from there on. Your film and your art is valuable to the filmmakers and especially and musicians as well. Art is not funded very well in this country, and we certainly have stayed alive as filmmakers and have been able to continue making films by selling and owning our films. And as different mediums come out, such as video or DVDs or cable television, by being able to sell them in those markets. It's a very complex issue, especially being on both sides of it. And all I can say is that there has to be a kind of fairness about it. Artists have to make a living as well, and I think art needs to be somewhat protected. It's different than a lot of other trademarked or items or, you know, what James is talking about. At the same time, I think we've always dealt with a kind of openness in terms of our work. Plenty of people through the years have copied the card scene in Don't Look Back. Don't Look Back starts with Bob Dylan holding up these cards that have the words of his song on it, and I'm sure you've all seen it in movies like Bob Roberts. You know, bands have done their own versions of it. We've never gone after any of those people. There has to be kind of a sane way of looking at things. You know, I also take the view, you know, in terms of, you know, there's just too many restrictions. You know, there's not going to be any documenting of our culture, and that would be a very sad thing to come. And you know, I think we get very close to that when everything gets so litigious about every item that you can't have some kind of freedom of expression about things, about ideas.
I'm in the business of acquiring and licensing older films. I acquired a whole film library at one point, and then of RKO films and some other things.
And commit legal assault and law.
This is a clip of a Kubrick film that he made before he was making feature films called Day of the Fight. John, who's doing RAV, has seen this in film school, and the proprietary part of me said, where did you get this to watch in film school? But I'm glad he watched it. So I am on both sides of these issues, and I have made a living taking films that have been made, or television programs been made in the past when new rights opened up, cable, DVD, et cetera, and those rights are in dispute. Sometimes there are opportunities to make money with them. These all depend, of course, on copyright regimes. So I am betwixt and between, but my heart is certainly for openness.
What does the fan look for? Competitive sport, scientific skill? Partly. But mostly he seeks action. Toe-to-toe body contact, physical violence, the triumph of force over force, the primitive, vicarious, visceral thrill of seeing
So for those of you who also know the film Raging Bull, look how, if you remember, look how much this looks like Raging Bull, and how much Scorsese obviously lifted. I think if you played the two of them side by side, you would wonder whether Raging Bull infringed on this film to some degree. The staging of it, the way the bodies move, the angles, the hair, everything.
What is the point of this whole body of law? Why do we have copyright? Why do we have rights of publicity and so forth? And it's all too easy, and I fear that it's courts do it quite a lot too, to lose sight of the underlying goal and instead simply to proceed by applying a bunch of rules without any sense of that the rules were actually there for a reason. The goal of copyright is to encourage progress and also to encourage dissemination of work. If you were, so to speak, the copyright czar and you were grading the balance that we are currently striking, how would you grade it in terms of that goal? The goal of encouraging progress, that is to say, encouraging people to make new works. Now, obviously, making new works, there's a lot to encouraging it. On the one hand, as Chris pointed out, making new works is expensive. You need to get paid for it. To get paid for it, you may need a legal right. One of the rights is a copyright, which you can trade away. That gives you a power to make a deal. The deal pays, and this is why we care about it, for the work that you're going to do. You can say, I'm going to be paid for this, so you can get someone to invest in it, or you can run it up on your credit card and believe that one day you're going to be paid for it. You can make your movie because of that right that you're going to be traded away. That's one of the goals. But another thing that you'd have to do in setting this scheme up is also to assure access to raw material to make movies in the future. I mean, Chris's clips in particular pointed this out. As Jennifer said in setting up the conference so eloquently, Documentary films are records of our culture, but our culture is full of copyrighted culture. If you walk around the streets, actually just try doing this. Walk around the streets and try not to encounter something copyrighted or trademarked. Cover your eyes or your ears. The moment that you hear someone playing a song, the moment that you walk by a storefront that has a fragment of a movie being played, the moment, although this turns out not to be the law, but rather what some very bad legal advice suggests the law, the moment that you see a trademarked logo going by you, imagine as it were blurring out intellectual property from the world. What would be left? Not very much. You'd have a kind of Giacometti sculpture vision of the world with all of the reality stripped away. Copyright law should be designed to minimize the amount of legal knowledge needed, to make the law easy for lawyers to understand, but easier still for artists to understand. That's not necessarily the law we have. So in the striking this balance between access and incentives and control, has what we've heard so far, does it indicate we're striking it in the right way? Now, copyright law, as you'll hear over the course of the day, strikes that balance in lots of different ways. It does it in one way by saying certain things just aren't copyrightable at all. So facts aren't copyrightable, ideas aren't copyrightable. But the trouble is, particularly when you're making movies, that you're capturing the stuff that is copyrightable, expression, and also things that are protected by other rights. There you may have to turn to other copyright exemptions, in which one of the more important ones is fair use, which Chris mentioned. In broad terms, in the United States, fair use is a multi-factor analysis. The copyright laws give us a set of examples about what would be fair use. So, for example, photocopying for classroom use, or use for research, or for criticism, scholarship, and so forth. And then it gives us a set of factors to consider, which have to do with, for example, the effect of the taking on the market for the work, whether it's commercial or non-commercial, the extent that you take, the nature of the work from which you take it. Does it have thick protection because it's fictional, or thin protection because it's factual, and so forth. Copyright lawyers, many copyright lawyers love this doctrine because it has proven able to adapt to remarkably new technologies, in my view, generally very, very well. This is a flexible doctrine, which is good. Here's the downside with flexible doctrines. This works great if you can afford John, or if you can afford the New York Times lawyer, and that was the assumption of the Act, that fair use was being interpreted, if you can afford Chris's lawyer, that you were working with really excellent lawyers who had a mixture of legal knowledge covering all the circuits in the United States and practical judgment, because fair use is all about practical judgment. And that's really hard. Very, very smart people frequently don't have it. Right? I mean, you can know the law like crazy and not get it. What it may not do so well is cover the realm of the internet, where the people who need to be able to make use of the fair use doctrine have no lawyers at all. And that's one of the ways in which this wonderfully flexible doctrine may not work so well. I happen to think that almost all of the things that we have been shown today should clearly be fair use. It's one thing if I went around saying, let's find someone playing a Madonna song on a boombox so that I can use that as a de facto track to get my music because I like the Madonna song and I want that in the background. But if what you're doing is, as Eric put it, capturing reality, and Madonna happens to be playing, it seems to me clearly that should be fair use, because what you're trying to do is not to steal, but rather to portray the reality you see around you. Where it gets more fascinating and more complex is where you add in all of the other rights that are involved, and where you add in some of the complexities of how all of this law, which exists on the books and in court cases, then gets applied in the business of making movies, where you may not be dealing with a judge or a legislator, but rather someone who deals with insurance, or someone who's a distributor who needs to be calmed down. So imagine that I'm an eager documentary filmmaker, and I'm convinced that I'm going to be a new Hegedus, Pennebaker, Saltzman, whatever, and I go out and I decide that I'm going to do a second version of the War Room. I'm going to follow the Kerry and Bush campaigns, and of course in the course of this, political campaigns are constantly playing music, taking other people's advertisements and so forth, and putting them on, and I go around recording all of this, but I'm also recording the staffers playing songs. I'm watching them watch TV, the same kinds of things, playing video games, and also making commentaries on the video games, comparing them to current political figures, mainly Arnold Schwarzenegger. I've got shots of those kinds of people, and I think it's absolutely brilliant. I'm convinced of my own brilliance, and somehow, and of course this would not actually happen, I managed to make my way into John Sloss's office, and I slam the film down on the table, and I say, here it is, it's great, and it's all protected by fair use. Now tell me, what needs to happen before this goes on a screen?
What I say is, well, if we can get an insurance company to give us an E&O policy to cover this, then let's make it their problem.
What's an E&O policy? Because I'm a total neophyte. See, I don't know these things.
It's errors and omissions insurance, and it's meant to cover all the issues that would arise from someone coming after you for everything you've basically stated.
No, it's all fair use. I don't need insurance. Let's just go ahead without insurance.
Well, you've made my job more difficult than it would be incumbent upon me to persuade the exploiter, the distributor, or the broadcaster, or whomever we're trying to license.
A distributor?
Well, maybe not. In the future, in the internet, if people have wide enough tubes, then you can actually just put it up on your site, and that's an interesting conversation. But yeah, I mean, if you're coming to me saying I don't need insurance, then you've basically taken yourself out of the ball game for the people who are the conduits to a broader public. My immediate response would be to say, get a website and put it up, and then find a way to get to people with broadband so they can come directly to you and see your work.
But I know I like the idea of seeing it on HBO or the Discovery channels. I want to go to So who gives these E&O policies? These are nice people, I'm sure. Why don't we explain to them that it's fair use?
Yeah, it's funny. It's a very tricky, ever-changing world, and it's kind of an interesting shell game or poker game, because what you have is a number of insurance companies. The main players are the insurance companies, the brokers, who can really go through to all the insurance companies and who are your friends and really the middlemen between us and the filmmakers on one side and the insurance companies on the other. And then the lawyers who are employed by the insurance companies, and this is a really small group of people.
So now, let's say, is there any pressure? So one thing I was kind of hoping for was that there would be this competitive market where different insurance companies would push each other to be more risk-prone, or other ones would be more risk-averse, and there would be this jockeying, and this would try and give me a spread. Some ones would be more avant-garde. What you've told me doesn't reassure me, and this is an interesting link between media concentration and the actual application of the fair use doctrine. Do I have any hope from the distributor side? If there isn't a push,
well, it's interesting.
Is there a pull side?
It's interesting. I guess I'll say two things about that. The insurance business used to be much more competitive in this realm. An event occurred a couple years ago that actually I think is seen as the root cause of that reduction in this competitiveness. And I suspect that no one in this room could guess what it was. But it was 9/11. And what happened, that event shook the insurance policy for obvious, or the insurance industry for obvious reasons. And I think its impact was seen in a lot of different places. And oddly enough, one was in the copyright world, or in the motion picture world. I think this was seen as a high risk, less profitable part of the business that insurance companies provided, and it's really taken a hit. The other, I guess the other point I wanted to make is that we had a really interesting case study in exactly what you're talking about at Sundance this year, and that's with the film Super Size Me. Of any of the films at Sundance, it was easily the most popular. But what happened is that there was a stampede of end users, of broadcasters and conventional distributors to pick up the film. We had an errors and omissions policy, a standard errors and omissions policy going into Sundance. There was one little wrinkle. It excluded claims from the McDonald's Corporation. So it was our job to both manage the wild excitement of all the potential buyers in the context of this sort of hothouse environment of Sundance, and as the sales agent and as the lawyer, explain to them how they shouldn't worry at all that the errors and omissions policy excluded McDonald's. And it really led to a lot of very interesting conversations, and it led to a very interesting process.
There are a couple of things I want to talk about. Is this idea of the historical documentary filmmaker and the enormous job we have to clear all the materials that we use in a documentary, but also the fact that in that process you're also looking at a kind of limitation on not only the use but also the life of the film. There are quite a few films that I've been involved in that are no longer in circulation. Frederick Douglass, Eyes on the Prize is not in circulation anymore, in home video or on television. Malcolm X, Make It Plain, it's not available on television or in home video. The Great Depression that we did at Blackside has lost its rights. Dancing, which I did for film segments for WNET. Even Africans in America is soon about to lose its license on public television. And the only way it can go back on is if, in fact, people decide they want to pay that licensing fee again, and then also go back and pay the fees to those who have offered us material in the films. Which is not a small thing, especially if those films come out of your independent company like mine. There's no way I can go back and come up with maybe the $100,000 to $200,000 it costs to license the footage, and that's not talking we're not talking about licensing the music as well. As a program officer of the Ford Foundation, I find myself back involved with Eyes on the Prize because we're actually trying to get it back on the air and back in circulation. And one of the things I'm trying to I guess seed as a discussion with those that I'm working with, those who own licenses and that we're talking to about getting it back in circulation, is there some way that we can take historical pieces that are in many ways not only a record of history and a valuable piece in how we teach history, but also a record of the moment in which they're made, and something that and acknowledging the fact that this is something that's going to keep going on from one generation to the next. We hope that moments in history are continually interpreted in each new generation. How do you take these pieces and allow them to be openly available to the public? Is there some way we could decide that after renewing rights and licenses so many times, they can fall in some sort of semi-public domain status or in a total public domain status? Is that something as a society that we think is important? I think these are all big issues that we're dealing with, and ways that not only, it's not something that just takes place in the offices of lawyers, but I think has to be something that is a part of a public discussion. And the last piece that I did is a really complicated piece, because I went back to a historical documentary piece in this era of the civil rights movement. I had for a long time tried to develop a documentary on Dr. King. And this last year was his 75th anniversary of his birthday, and I felt it was very important to bring his voice back into the kind of public discourse around issues of war and poverty. And had for the last 6 years been actively pursuing it, writing scripts and proposals and trying to get the film in motion. Where I found resistance was from those who were the heirs of the estate, not from the archival houses, not from the photographers, not from those who worked with them, but those who were the owners of the estate. And we were in long negotiations, and at a certain point I decided that I had to just move forward and make this film because I felt it needed to be made now. It got kind of ugly for a while. It got very ugly for a while. I did this with the American Experience, and we had to indemnify all of the licensees, all the archival houses, all the photographers, when we, in producing this film, and convince them that we were working in, again, this space called fair use. Fair use in the context of who has the right to interpret history. And when is a person a historical character and one available to all of us, and when is it one that's protected by the rights of an estate? It's a very complicated discussion.
Or any other occasion. I remember Easter of 1963, when my husband was jailed in Birmingham. I had just had my fourth child.
One of the things that that became such a real challenge was that, or problem was that we wanted, it was very important for us, that we really wanted, number one, Mrs. King in the movie, and because of our difficulty negotiating the making of the film, we could never get to that place to even engage that conversation. The other piece was that what we were really fighting over were his words, and to hear his voice and to experience his voice in the film. And how can you make a film about Dr. King and not, you know, hear his voice and not hear and be privileged to his words?
For redemption.
I've long since learned that be a follower of Jesus Christ means taking up the cross. My Bible tells me that Good Friday comes before Easter.
The other interesting piece about the difference between this film and Eyes on the Prize is that I no longer use recorded music. That all the films I work on now are scored, because I think if we're going to have a really difficult time bringing Eyes back into making it available to the public again and bringing it back into the classrooms and into the public, I don't think we're going to be able to crack the nut of the music industry. That is the hardest license to negotiate, and that has become much more consolidated and difficult to engage in any sort of kind of what's the right word when you have one fee for everyone. Favorite nation, even a favorite nation negotiation. So that's going to be our most difficult task. So it's a possibility, and that would be a real shame that if we bring it back, we'd have to score the entire 16 hours, which takes so much away from that record of history. With that, I'll end, and we can ask questions.
Can you tell us a little bit about the licenses that you got, such that we could actually have this historical artifact, Eyes on the Prize, which has been so important, not be available to future generations to see as a public artifact? What were the licenses? How long did they last? And why are they now in danger of running out?
Well, in the case of Eyes on the Prize, we're operating on standard licensing agreements. I mean, for broadcasts, and we're usually clearing just PBS broadcasts, which is a separate standard in terms of cost and licensing. I think PBS asked for 6 years now, or 4 years and 6 broadcasts. That's on a national broadcast. With home video and with that comes the right to distribute in classrooms and for educational use. And I think that lasts about 12 years. But then PBS has to re-up their license to then broadcast it each time. Now when we clear, and PBS also, because it's very actively involved in selling its products now. So a lot of its products find their way into a lot of different forms and sold in a lot of different ways. DVDs, enhanced DVDs, home video. And I think when you move into that realm, that's when it becomes, like we said, the Eyes on the Prize is an interesting example, because immediately after the series came out, people said, wait a minute, these things make a lot of money. They can make a lot of money. Those who are licensing material are also much more clear of the potential profit, and therefore it's not like you're getting deals or you're making deals around those things. With this King film, our archival footage licensing cost came to a total of $180,000. That's a large amount. Now, for an independent producer, you're asked to estimate what your costs are going to be going into the film. On this King film, I estimated that my cost would be $80,000. So obviously, I'm a little bit over budget, and I was able to raise a bit more to kind of to address that, but I ended quite a bit over budget. And I mean, that's the and I think that in a funny way, it's causing a lot of us to kind of to move out of the business. It's hard to kind of maintain and to participate in this kind of documentary filmmaking, historical documentary filmmaking.
Let's suppose that it isn't politic or practical to suggest scrapping intellectual property, as I would actually like to do. Caring, let me just say in passing, by the way, nothing at all, not a fig, for the claims of those of you who believe that you are entitled morally to the benefits and to the recognition for what you have created. For I don't recognize that entitlement. I don't wish to give it to you, and I don't require it of you with respect to me. It's perfectly okay, I think, to behave with respect to these kinds of propositions as the sainted Jerry Garcia behaved. As he said, once we played it, it's yours. And that's not a bad rule to live by for a creative person or a creative artist. It does nothing to impede creativity in any serious or important way. But let's suppose, as I must, that this isn't a very practical set of suggestions. We have, in the history of copyright law, mechanisms that would need a little dusting off, but they could lead to this regime in law, which I propose to you that we all ought to work toward collectively. For I think it would give us much of what we want, those of us who wish to have attribution and acknowledgement, that part of moral rights that I think does exert some claim and pull. And it would at the same time rescue the documentary filmmaker from the sorry state into which he and she have fallen. This is what we would do. We would divide the questions in roughly this way. We would deal with the question of appropriation, which is what's really involved when you worry about licensing. You are in a position of having appropriated something that belongs under the law to someone else. We would replace appropriation with what is the equivalent of a compulsory license, so that there would no longer be a question of whether you could license the rights. Indeed, you could. That's easy to do. It's not at all hard. In fact, there are numbers of compulsory licenses in the Copyright Act, and while proprietors of the copyright law and copyright rights maintain quite earnestly, and I think from a sincere conviction, that that's not a good idea, I put it to you that at least in the case of documentary production, it wouldn't be a bad idea at all. Very little, in point of fact, would be lost to the proprietors of rights. I would then say that with respect to those rights that are destined for non-profit exploitation, we impose no licensing fee at all. Indeed, the compulsory license simply applies, and that's that. So if you are in the position of doing a documentary in which you propose to do it, but you don't actually propose to make a profit from it, it's fine. Take what you want, make the documentary, understand that you will be limited in the profits that you can earn, but nothing more than that will impede you as you propose to work. Now, if you shift across the line into a for-profit setting, it is true I propose that you pay a license, but I want you to understand that the license would not be gauged by the present measures by which we value works that are appropriated. There would be no statutory damages to be paid, because no damages would be recognized. This isn't a question of damage. This is a question merely of an obligation to pay. And how would you pay? You would pay according to the value of the work you appropriated in the work that you had created. So when you're done, it's a very simple kind of regime. Now, for those who don't like the regime and whose response is likely, therefore, to be couched in a kind of end run, who will say, in other words, why, this isn't practical, this would pose all kinds of problems, let me tell you that none of the problems that you would imagine it posing have not been faced over and over and over again already over a history of copyright law that goes back all the way to the 1909 Act and before. Item, the distinction between profit and non-profit uses, a standard distinction observed with respect to performances under the 1909 Act, and one as to which there are literally scores of cases delineating the difference between profit and non-profit uses. Not easy, but not difficult, and by no means new territory. We would only have to distill old wine in new bottles. As to the difference between appropriation as of right and the appropriation that can be had only with respect to a license, once again, a clear history in copyright of this kind of right. It's called the compulsory license. We had it in Section 1E from 1909 forward. We now recognize it in a number of settings. Nothing new about that, nothing more than dusting it off a bit at the edges. The idea of treating a kind of work categorically as entitled to this sort of protection, nothing remarkable about that either. For we treat works categorically as entitled to a certain kind of right in copyright and have done so for a very long time. Item, we have recognized for a considerable period of time, since Two Live Crew appropriated the rights in Roy Orbison's song Pretty Woman, that generally parody does have a wider scope of protection under fair use, and it would be not difficult to recognize the same kind of wider scope of protection for documentary films, but with the additional apparatus that I proposed, an absolute right to appropriate and a distinction between paying nothing in the case of not-for-profit uses and something in the case of for-profit uses, work of a moment, not a moment, a work of a little while, to work that out. Now, one last thing in the minute that I have remaining. What about the fee scale upon which you would be expected to pay were you to engage in an appropriation for a documentary film and then move toward a for-profit exploitation? As to this, it seems to me that you would engage in exactly the same kind of conceptual valuation of the appropriated material in the new work that you engage in now when you measure damages, and where in every instance in which you're not relying on statutory damages, you actually do take a look at what the thing that you've stolen or infringed is worth in the thing that you've created. Because the truth is, when you infringe, though there is a presumption against you that I don't have time indeed to explore, the fact is that the court isn't working to punish you by taking everything that you've earned. What you are obliged to pay is for the value of the thing that you have appropriated. Not a thing that I'm proposing is conceptually new. Nothing is involved other than reconfiguring the place and the role of the documentary in the field of copyright. It's not always easy, and there would be some complaining about that if we relied on an approach to the standard as open-ended and indeterminate as that, so that I imagine that we would begin to substitute a scale that would probably be worked out as fair use benchmarks are worked out, taking categories of work appropriated into account, the amount of the work appropriated. We begin to value the works in a kind of categorical way. That isn't wholly satisfactory, but I believe it to be more satisfactory than the kinds of negotiations to the point at which the owner of the previous work can say no that we're now confronted with. Because what I want to get around is the ability of someone to do what would be done with the video that Jen and I produced for a very different purpose that you can see in an hour or so, where there are some of the works that we use that you couldn't license, that simply aren't available for licensing. It's the ability of the owner of the work to say no that I want to circle around. And there will be some arbitrariness in getting around it.
I'd like us to thank the panelists for what I thought was just a truly remarkable conversation.